The topic for today, as you know, is evidence and trials in civil suits, learning the nuts and bolts. So before we dive in, let me explain how I actually propose to go about this today. So when I studied the Evidence Act in college, when I read it for the first time, I didn't really understand it too much. I couldn't really connect with it. And honestly, I found it a little boring. I didn't like the subject too much. But later on, when I got into practice and I saw how the act is actually applied, I realized that this is really a very beautiful piece of legislation. It is based on some fundamental principles of equality or justice, logic even. And it is because as students, we are not able to understand those fundamental principles because we are not able to practically apply them, that we find it sometimes a little dry, sometimes maybe a little boring, a little difficult to understand. So therefore, I thought that if we have a webinar explaining these fundamental concepts through a case study, which Malvika said has been shared with all of you, then maybe we can take examples from that case study, see how they can be applied to these fundamental principles, and then maybe we can try and enjoy the subject, right? So what I'm going to do today is I'm going to first of all cover the basic fundamental principles. So I'm not going to really get into even sections too much. I'm not going to read the sections. I'm not going to get into too much case law. I'm just going to look at principles and we'll try and understand why those principles are applicable. So tomorrow we will be framing the issues in the matter. As you all know, the case study is an accident or compensation case, right? So we will be first framing the issues. There are 4 witnesses, as you are aware. So what we will be doing is we will take each witness and we will try and understand what are the areas on which that witness should be cross-examined. And then I would really like all of you or a few of you to try your hand at cross-examining the witnesses. So for that purpose, what I've done is I've requested 3 of my friends here to act as witnesses. So we have 4 witnesses in the case. I have Pratik Divkar, who will be the applicant. I have Karunya Raghunath, who will be the respondent. And then we have one witness for the respondent, who is also going to be joining us tomorrow. So maybe let's just get started. So first of all, we start with the difference between pleadings and evidence, right? So what are pleadings? Pleadings are statements in writing which are prepared by and filed by each party to a case. So what will the pleadings contain? The pleadings will contain the facts of the case. The pleadings will contain what the claims are. All the details which the opponent needs to know in order to prepare his case should be contained in the pleadings. Now, pleadings, as you all know, are the foundation of the case, and the issues which are in dispute between the parties are determined on the basis of pleadings, right? The word pleading is defined in the Code of Civil Procedure in Order 6, Rule 1, as pleading means plain to a written statement. This is, of course, in case of a suit, right? So in a case of, for example, arbitration proceedings, the pleadings would be the statement of claim filed by the claimant and the statement of defense filed by the respondent. Here you have the applicant preparing an application. So the application is the pleading of the applicant, and you have the opposite party giving its written statement. That is the pleading of the opposite party. Now, what is evidence? Evidence is the material or the testimony which is presented in a court of law by which each of the parties proves or disproves the claims made in the pleadings, right? So, for example, if a plaintiff says that I supplied goods to the defendant, but the defendant did not pay for the goods. Now, if the defendant wants to disprove what the plaintiff is saying, he wants to show that he had paid for the goods, he will produce the details of payment. So he will show that I made an internet bank transfer or whatever, right? So that is the evidence, the material which is presented by the defendant to disprove the claim of the plaintiff. Now, as we know, evidence can be either oral testimony or it can be documents. Now, documents include electronic records as per the Evidence Act. Oral testimony now, as per the CPC, is really done away with because the CPC now requires that oral testimony is in the form of affidavits in lieu of examination in chief. So earlier, the witnesses used to step into the witness box. There were questions put to them in examination in chief by their own lawyers. The entire story of the case was brought out through that examination in chief, and then they were cross-examined. Now that is the examination in chief in court is really done away with, and you have them filing your affidavits of evidence, and then there is cross-examination based on the affidavit of evidence. Now, evidence is defined in Section 3 of the Evidence Act as oral testimony or documents. Now, we come to what is the difference in analysis of evidence in civil trials versus criminal trials. Okay, in civil trials, while analyzing the evidence, the court considers or looks at a doctrine called the doctrine of preponderance of probabilities. Now, what exactly is this doctrine of preponderance of probabilities? So, for the court to decide whether a particular fact which is alleged exists, it will look at all the facts which have been brought on record by the plaintiff, all the facts which have been brought on record by the defendant, and then it will weigh them. It will see where it is more likely that whether the plaintiff has proved that the fact exists or the facts which have been brought on record by the defendant are more probable and show that that particular fact does not exist. So that is preponderance of probabilities. It is not something which is beyond reasonable doubt. That is a doctrine of proof which is generally applied in criminal trials. Because in criminal trials, it is the liberty of a person which is at stake. So therefore, the standard of proof in a criminal trial is much higher. There, even if there is one small reasonable doubt, then the court may say, sorry, the prosecution has not been able to prove its case, and the person may not be found guilty. But in a similar situation in a civil trial, the court may feel that, all right, he may not have proved beyond reasonable doubt, but whatever is being brought on record suggests that the probability of that thing happening is so high that I should take it as having happened, and the court ultimately decides that that fact has actually happened or that fact has occurred. Now, this principle of doctrine of preponderance of probabilities is encompassed in the definition of the words proved, disproved, and not proved in Section 3 of the Evidence Act. Let us just quickly look at Section 3. I'll read it out. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. So either the court believes that that fact exists, or it considers that its existence is so probable that a prudent man would think that it exists. In such a case, that fact is said to be proved. So this is really what is preponderance of probabilities, not proof beyond reasonable doubt. And the definition of disproved is exactly the opposite, logical, right? So a fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. So therefore, the court either believes that whatever you brought on record makes it very clear that this fact does not exist. Then it says this fact is disproved. Or it may not exactly be very clear that it is not beyond reasonable doubt that this fact exists, or fact does not exist. But then the court thinks that no, the facts which have been brought on record make it very probable that this fact would not exist. And if a prudent man was considering the evidence, he would think that this fact does not exist. Therefore, the court will hold that this fact has been disproved. And what is not proved? A fact is said not to be proved when it is neither proved nor disproved. So when the court can not say that this fact exists or it does not exist, then the court will say that it is not proved, it is not disproved either, therefore it is not proved, right? That is the difference. So there is a very good decision of the Supreme Court in the case of N.G. Dastane versus S. Dastane. The citation is AIR 1975, SC 1534, which explains the difference between doctrine of preponderance of probabilities and doctrine of proof beyond reasonable doubt. This is a 3-judge bench of the Supreme Court, and if you'd like to refer to it, that will be helpful. I'll repeat the citation. It is N.G. Dastane versus S. Dastane, AIR 1975, SC 1534. Now we get to the next slide, which is there are two fundamental principles of evidence which we must keep in mind. The first is the rule against hearsay. Now, what does hearsay mean? It is a basic principle of evidence that evidence must be direct. So if you want to prove that a fact exists, a person who himself knows that that fact exists must give evidence. Why is that? Why is this a basic principle of evidence? Because it is only upon cross-examination of the person who says that something exists can it be proved that he is saying something incorrect. Or if through cross-examination you're not able to prove it, then that person is said to have proved his case because you have not been able to shake his testimony by cross-examination. So therefore, if a person says that he has seen something happening, then he should file his affidavit of evidence, say that I have seen this fact. He should give an opportunity to the other side to cross-examine him. And that is when it can be said that that is direct evidence and not hearsay. So if A says that B told me that C did so and so, the evidence of A would be hearsay because A has not seen C doing the act. A has been told by B that C has done this act, right? So the person who should give evidence in this case would be B because he's the person who has actually seen C performing that act. And therefore B should come and say that, for example, C has stolen a watch. And then the advocate for C will cross-examine B. If A comes and says that B told me that C has stolen a watch, A's evidence would be hearsay and would not be admissible in evidence. Now, Section 60 of the Evidence Act encompasses this principle. So it says oral evidence must in all cases be direct. So if something was seen, the person who saw it must give evidence. If something was heard, the person who heard it must give evidence. If something was felt, the person who felt it must give that evidence, right? Now, the next rule is the best evidence rule. Now, in every case, when as a lawyer, we determine what is the evidence to be given in trial in favor of our client, we must think about what is the best evidence in this matter that I have. And it is my duty to first put across that best evidence. If that best evidence is not available, then I might put something which is slightly lower than that. If that is not available, slightly lower than that. Again, this principle is encompassed in certain sections of the Evidence Act, several sections, in fact. For example, Section 91. So Section 91 of the Evidence Act says that when you want to prove the terms of a contract, you must produce the contract itself. The oral evidence of what are the terms of the contract would not be admissible. Right now, why is that? Because the best evidence is the contract itself. If you produce the contract, then it is clear what its terms are. Why should a person say that I'm not going to produce the contract, but I have read the contract and the contract says XYZ? The best evidence would be for a person to produce the contract and the person on the opposite side can read it and see if the terms say what he's alleging that they say, right? So that is the best evidence rule. And in fact, Section 114 of the Evidence Act also contains a presumption against a person who has or should have certain evidence and does not produce it. Then the Evidence Act says that the court may presume. It is not a mandatory presumption. It gives a discretion to the court, but it says that the court may presume that if that best evidence, which should have been with that party, was brought on record, that would go against that party, which is why he is not producing it. So the court may draw an adverse inference against that party. That is what is meant by adverse inference. So if you have some evidence, for example, I have a contract and I do not produce it, but I say I try and rely on that, the court will actually say that this is, I will raise an adverse inference against you because you should have produced the contract. There must be something in the contract which is against you, which is why you're not producing it, right? So that is the best evidence. Yeah. So now let us look at documentary evidence. Whenever a document is being produced in evidence, there are two aspects which must be considered. One is proof of the existence or contents of a document. And the second is proof of truth of the contents of a document. Now, what is meant by both these aspects, right? If you want to prove that a document exists, how will you prove it? How will you prove that, for example, a letter was sent by A to B? How will you prove it? If A alleges that he had sent a letter to B and he wants to prove that that letter exists, he will produce the letter in court, right? Now, not just produce the letter in court, what will he do? He will identify his signature He will say, this is the letter which I had sent, this is my signature, I had sent this, and he will produce proof of delivery to B. So that proves the existence of the document. It proves that the letter was sent by A to B. If A wants to prove the existence of a contract, for example, A will produce that contract in court and say, this is my signature, this is B's signature, and this is the witness's signature, and he has proved the existence of that contract. Right? Now, if you want to prove that what is written in a letter is true, right? That you want to prove the truth of the contents of the letter, how will you prove it? Will it be enough to produce that letter and say, can A say that I have written the letter, B has received the letter, so therefore whatever I have said in that letter is true? Can it be claimed that whatever is said in the letter is true just because that letter is produced in court? If, for example, A says in the letter to B that C has stolen a watch, okay? And the point to be proved in the case is whether C has stolen the watch. Just by producing the letter in court and filing it and proving that A had sent this letter to B, is it proved that C had stolen the watch? You have just, what has been proved is that A told B that C has stolen a watch. A sent a letter to B saying C has stolen a watch. Now, if A wants to prove that C had indeed stolen the watch, then A, who has written the letter, must give evidence in the matter, and he must say, yes, whatever I have seen, whatever I have said in the letter is true. I saw C stealing the watch. Then the other side will cross-examine him, and that is when his evidence can be said to be admissible. So how is the truth of the contents of a document proved? By the author of that document coming and giving evidence and saying that, yes, what I have said in this document is true, and then the other side gets a chance to cross-examine. There is a very good decision of the Bombay High Court in the case of in AIR 1983, Bombay 1, which very easy, in a very simple manner, in a very succinct manner, explains the difference between existence and truth of contents. Often in practice, we kind of we tend to confuse the two. We say you prove the existence of a document and you prove the contents of a document, but contents also really are the existence only. So when you prove the contents of a letter, you produce the letter and you say that the letter says XYZ. So therefore you're proving the contents, which is proving the existence. But proving that XYZ is true is proving the truth of the contents. So proof of existence or proof of contents of a document is one aspect, and proof of truth of contents of a document is another aspect, and both are proved in different manners. Now, as far as existence or contents of a document are concerned, again, there is a question of, you produce the document, but there is a question of primary evidence and secondary evidence. There's a concept of primary evidence and secondary evidence. So wherever possible, the evidence must be primary. What is primary? It is the original document. The original document produced in court is primary evidence of the existence of that document. What is secondary evidence? Secondary evidence could be copies, it could be photocopies, could be certified copies of public documents. So those are secondary evidence. Now, there are certain sections in the Evidence Act. There are only certain situations in which secondary evidence is permitted. So in all cases, evidence must be primary. But in certain cases, like, for example, if the original has been lost, or the original A wants to prove a document against B, but the original is with B, right? So A is not able to prove that document. So then there are certain conditions in the Evidence Act. So one of the conditions is, section 63 to 65 of the Evidence Act are relevant. So one of the conditions, if the other party has the document, so you are required to send a notice to produce to the other party, saying that you have the original document, please produce it. If he produces it, then that original document can be put into evidence. If he does not produce it, then the person giving the notice is entitled to put in a photocopy, saying that I don't have the original, the other side has the original, he is not willing to give me the original, therefore I'm putting in a photocopy, and then that would be admissible secondary. And of course, if a document is lost, then you have no option but to give a copy of it. And you must say in evidence that this document is lost, which is why I'm producing a copy. Now, the next concept is the concept of burden of proof. So there are two aspects here as well. What does burden of proof mean? and on whom burden of proof lies. So sections 101 to 111 of the Evidence Act are relevant in this regard. What do you mean when you say burden of proof? What we mean is who is required to prove a fact? On whom is the burden to prove this fact? That is what is burden of proof. And on whom does this burden of proof lie? So section 102 says that in a suit or a proceeding, the burden of proof lies on that person who would fail if no evidence is given on either side in a suit or proceeding. So therefore, generally, the burden of proof is on the plaintiff, correct? Because if the plaintiff comes to court with a case and there is no evidence led on either side, and the plaintiff makes certain allegations against the defendant, and there is no allegation or there is no evidence on either side, the plaintiff would lose the matter. The plaintiff would not succeed. Therefore, the burden would be on the plaintiff. Generally, that is the case, right? Then again, those sections talk about in each individual case on whom the burden of proof is. It is absolutely logical if a person asserts a particular fact as a defense. For example, if the plaintiff comes out with a case that there was a contract which I had entered into with the defendant, and he files a suit for specific performance. Now, the defendant accepts that, yes, this agreement was entered into, but then he says, but I was defrauded. My signature was taken by fraud, for example. Then the burden of proving that fraud is on the defendant because he is alleging that fraud. He is not denying that he has signed the document, but he's saying that my signature was got by fraud. Therefore, the burden of burden of proof in that case would be on the defendant. Right? So all of these sections, 101 to 111, explain in a very logical manner where the burden of proof in different cases lies. In the case study, for example, which we have here, the plaintiff has made a claim that he suffered injury, that he suffered damages of 7 lakh rupees. Naturally, the burden of proof is on the plaintiff to prove that, right? So he will have to come and say that I suffered injury, I spent this money, this is the damage caused due to the negligent act of the defendant, right? Therefore, the burden of proof here is on the plaintiff. Now, we get to examination in chief. Now, what exactly is the object of examination in chief? As I said earlier, of course, now we do not have oral examination in chief, we have it on affidavit. Of course, it is still permitted even after you file an affidavit of examination in chief. If you have further questions, with the leave of the court, you can ask further questions to your witness, which would be further examination in chief. Okay. So the object of examination in chief is to obtain from the witness the facts which are required to be proved in favor of the party who has called that witness. Right? Now, one basic principle here must be that the evidence must be that of the witness and not of the advocate. This especially is significant in cases where you have oral examination in chief, where you're not permitted really to ask leading questions, where you're not allowed to give a hint to the witness on what the answer should be. You should leave it open because the witness is the one who's giving evidence, not the lawyer. The witness must tell his story, right? So the facts must come from the witness. Similarly, of course, this must also apply when you're drafting an affidavit of evidence for your client. The facts must come from the witness. The facts cannot be put in by the advocate. The advocate, of course, will determine which facts need to go in, which facts need not, which may not be necessary to prove a particular case, but the facts must come from the witness. Often we see that in practice, people just kind of copy paste the pleadings as a part of the evidence. Now that really must be avoided because as we saw in the beginning, there is really a distinction between pleadings and evidence. Pleadings only need to contain the material facts. Evidence is the material which proves those facts, right? So there is a distinction between pleadings and evidence. Of course, in your affidavit in lieu of examination in chief or in your oral examination in chief, whatever is coming in must be supported by a plea. Pleadings are the foundation. So what you say in your pleadings must be supported by evidence. So if you've not made a pleading in your say plaint or your written statement, then the witness cannot say something which is in support of a non-existent plea, right? Again, the plaint must contain the facts and not the evidence. And there has to be, of course, no variance between what is in the pleading and what is in the evidence. Now, this, of course, seems very basic, but sometimes it does happen that a party has come with a particular case in the pleadings, but what is put in evidence is something altogether different, right? For example, that example which we took earlier about the specific performance suit, in the pleading, the defendant may say that, yes, I signed the document, I signed the agreement, but I was defrauded and my signature was taken by fraud, for example. But in the evidence of the witness, he says, this is not my signature. He cannot be permitted to give this evidence because this is not supported by the pleading. His pleading says that, yes, I signed the document, but I was defrauded. Therefore, his evidence must be in line with his pleadings. And finally, you have to understand that whenever you put something on record as an affidavit of evidence, it has to take place of what the witness would have said had he gone in the box and said it orally, right? So what could have been done orally is now permitted to be done by way of an affidavit. That's the only difference. There has to be no other difference. There have to be no unnecessary details. A lot of times people put in terms of a contract in their affidavit of evidence. Not required, because contract, as we said, is produced in court. The court can read the terms of the contract. The witness need not say that the terms of the contract are so and so and set out all the terms of the contract. The witness must only put in the affidavit of evidence facts which are to his personal knowledge and which cannot be determined from documents. Now we come to cross-examination. Now, what is the aim of cross-examination? The aim of cross-examination is to expose the inconsistencies, the errors, the exaggerations, and the omissions in the witness's testimony. What is the requirement for cross-examination? The requirement is to show that the other side's account of the facts is incorrect. So when you ask questions and you show that what the witness has said is incorrect, you are probably able to disprove his case. You're able to show that what he's saying is not correct. Now, in cross-examination, it is very important that the advocate controls the witness. Now, what do we mean by control and why is it required? Why should the advocate who's cross-examining control the witness? It is because you do not want the witness to run haywire and say whatever he wants and actually improve his case or damage your client's case, right? So you are giving him a chance to say something, but you should ensure that he says what you want him to say, right? He gives the answers that you want him to give, rather than him saying something in his own favor and bettering his case, right? Therefore, it is very important for the advocate to control the witness while cross-examining. Now, what is the way to control the witness? The most basic tool which is used by a cross-examiner to control the witness is to ask leading questions. So now when we come to the next slide, when we come to what are the tips on cross-examination, we'll get into what exactly we mean by leading questions. Okay, so these are some tips on cross-examination. So the first and most important tip is you need to be absolutely and thoroughly prepared with your case, with the facts. Without a thorough preparation of the facts, it is going to be extremely difficult for you to cross-examine. If you are not prepared properly, you may find that there is one fact in your favor. You may have missed out on some other fact. You put something to the witness, he points out the other fact, and your cross-examination falls flat. You have to be absolutely thoroughly prepared. You have to prepare the strategy on how you're going to cross-examine the witness. Now, with that, we come to the next point. You should know the aim of cross-examining each witness. Just because you have an opportunity to cross-examine doesn't mean that you go and ask any and every question. You have to be very clear in your head before you start on preparing for cross-examination as to what is your aim of cross-examining the witness. What do you want to prove? What are the answers that you want from him? And then you decide as to how you are going to get out those answers. Right? Now, one important tool of cross-examination is leading questions. So what are leading questions? Questions which suggest the answer. Okay. So questions which require a yes or a no response. So this is a way in which you control the witness. Questions in which the answer itself is included. Okay, so maybe I can demonstrate that. Pratik here, I've requested him to act as Mr. Singh, the applicant's first witness. So let us first put a question which is not a leading question, which is an open question. Okay. So here, the opposite party is trying to prove that Mr. Singh, who is the applicant, was not paying attention when he was driving. Right? That is the case of the opposite party, that Mr. Singh himself was not paying attention. I was not negligent. So now I'm the advocate for the defendant, for Bhatia, and I'm cross-examining Mr. Singh. So I ask him an open question, which is not a leading question. Yes. Mr. Singh, Were you paying attention to the road when you were driving?
Yes, I was.
So now what have I done here? I've asked him a direct question, and naturally he's going to say, yes, I was paying attention. Unless he is, really not paying attention here, he's going to say, yes, I was paying attention. And there's nothing achieved by asking him a direct question like this, right? As opposed to that, if I look at his affidavit of evidence and I see that he has said that we had gone for a sale, we were talking about the products which we purchased. So I asked him another question. You were talking to Mr. John Raj, weren't you?
No.
Yes. So now here, of course, the witness has said something which is contrary to his affidavit of evidence. So I point out the affidavit of evidence to him and I say that here you said that you were talking to Mr. John, right? So that shows that what he has said is not credible. And otherwise, if he had said yes, because he knows that he has said this, then I get the answer that I want. And from that, I can build a conclusion to say that Mr. Singh was not paying attention. I'll give you another example. We'll cross-examine Mr. Bhatia now. So now I will be the advocate for Mr. Singh, cross-examining the opposite party, Mr. Bhatia. Okay, so now the question was as to whether Mr. Bhatia was using a mobile phone while he was driving. Mr. Bhatia, of course, says he was
No.
But I asked him a direct question. So I asked him, were you using the mobile phone while driving, Mr. Bhatia?
No, I wasn't.
No, I wasn't. Now, that is a direct open question that I'm asking him. So naturally, he's going to say something in his own favor. Now I see that in his evidence, Mr. Bhatia has said that I'm almost certain that I put the phone down at the time of the accident. Okay. So I point out that part to him and I say, Mr. Bhatia, if you look at your affidavit of evidence, you say that you're almost certain that you had put the phone down. So is it possible that it is possible that you still had the phone in your hand at the time of the accident, isn't it?
Yes.
So then he says yes. And then we build on that to say that he himself is saying that it is possible that he had the phone in his hand. And this was a leading question because I put it in a way, it is possible that you still had the phone in your hand at the time of the accident, isn't it? So it is kind of directing him to the answer yes or no. And here it would have to be yes because he has said something which supports that in this affidavit. Now connected with this is the next step. Do not ever ask a question, the answer to which you do not already know. So this again is the same point that you do not give him a chance to elaborate or explain. So you do not ask him something and leave him, don't know what he's going to say and leave it open for him to say whatever he wants. Right? The next is avoid verbose questions. Verbose meaning do not make them very complicated. Keep them as simple as possible. This is for two reasons. One is that the witness must also, of course, understand what you're saying, right? You're not trying to confuse the witness, you're trying to get out the answer. Ultimately, that's the aim, even in cross-examination, ought not to be to confuse the witness, right? It ought to be to expose the incorrectness in his evidence. And secondly, if you ask too many difficult questions, one, the witness may not be able to answer, and the judge may think that there is something wrong. You're deliberately asking these questions in this manner so as to confuse the witness, right? So therefore, questions should be as far as possible, simple, not complex, not convoluted. Now, the next tip is do not argue with the witness. Often it happens that you put a certain question to the witness and the witness realizes that, he's probably going to be caught out now. So he starts arguing with you saying, yes, I did this, but I did not do that. And then the advocate argues, no, but you did this, you did this, you did this. Not required. Get simple answers from the witness and let the court decide, let the judge decide, because whom you're trying to convince is the judge, not the witness. We just need the answers of fact from the witness. We need to show that what he's saying is incorrect, what he's saying is exaggerated. That's it. And that comes to know when to stop, the next point. So you don't argue with the witness and you don't also ask too many questions. If you've got the answer, do not keep hammering the same point because at some point he will realize what you're trying to do and he will probably damage your case. So it is often said that better is the enemy of good. So if you've got a good answer, know that this is the point when you stop. Don't aim for better because it might get much worse, right? The next is seal off escape routes before you put an inconsistency to the witness. So often what happens is that the witness has said something in his affidavit of evidence. In his cross-examination, he says something which is completely wrong. You want to put that inconsistency to him and say that here you've said this, here you've said this, now which is correct. If you directly do that, then he may say that, oh, there is a typographical error in my affidavit of evidence. Or at that point of time, I was not very clear. Something like that, and he will try and get an escape route. So before you put the inconsistency to him, you try and seal off those escape routes. So you ask him questions like, have you read the affidavit of evidence? Do you agree with what is stated therein? Are there any mistakes in your affidavit of evidence? Let him give all the favorable answers, and then you put the inconsistency. Then you say, in your affidavit of evidence, you've said this. Now you're saying this. Or in your pleading, you have said this. In your evidence, you're saying this. Which of the two is correct? So that would be a more effective way to bring out the inconsistency, and it would be difficult for the witness to answer or to cover up that inconsistency. Now, the next is ask a series of non-controversial, factual questions to build to a conclusion. Now, what do we mean by this? So when we are determining how to cross-examine a witness, we first analyze the case and we see what are the points of dispute in the case. Once we determine what are the points of dispute, we say which are the areas from these points of dispute on which I can cross-examine this witness. I determine that area of dispute. Then I determine that in this particular area of dispute, what is the conclusion that I want to put to the witness? What is the conclusion that I want from him? What is the answer that I want from him? Now, if you put that answer to him directly, as we had seen earlier, he's going to not answer in your favor, right? So the way is that you first in the pleadings, in the affidavit of evidence, you try and pick out the facts which support the ultimate conclusion which you are going to try and get from the witness. So you pick out those facts and you say, these facts help me. And these are non-controversial facts. So they may be things which the defendant has said in his written statement. They may be things which he has said in his affidavit of evidence. Let him confirm all those facts first. So you ask him all those questions and he cannot say no. So he will confirm the facts. Then ultimately from those facts, you lead to that conclusion which you want from him. And then you put it to him. So then it becomes very difficult for the witness to answer unfavorably to what you want. It becomes very difficult for him to say no. Because logically that conclusion follows. If he says A, B, C, D, then E necessarily follows. Still a witness may say no. That is not the conclusion. E is not the conclusion. But then it becomes very obvious that he is not to be believed, right? So you're able to show. Of course, a person might say that these facts can be brought out from the pleadings. These facts can be brought out from the affidavit of evidence. Why do you need to ask these questions in cross-examination to the witness, right? Because it would have a much greater impact, right? If the answer that you want is coming from the witness, rather than you deducing it from the documents. If the witness himself admits it, or the witness says something which is so illogical that the court says that, come on now, he can't be saying this. This is an untrue. He's not to be believed. And that is definitely better for your case, right? So again, I'm going to request Prateek to take on the role of Mr. Singh, and I'm going to put some questions to him. Mr. Singh, in your application, you have set out the particulars of negligence. One of the particulars of negligence is that Mr. Bhatia did not sound his horn. Therefore, according to you, Mr. Bhatia should have sounded his horn when he was driving, isn't it?
Yes.
Yes. Therefore, according to you, if Mr. Bhatia had sounded his horn when he was crossing, you would have been alerted to the fact that his car was approaching, isn't it?
Yes.
Yes. Therefore, according to you, the accident could have been averted if Mr. Bhatia had sounded his horn, isn't it?
Yes.
Yes. So therefore, now according to you, if Mr. Bhatia had sounded his horn, your attention would have been brought to the fact that his car was approaching, isn't it?
Yes.
Yes. Therefore, you were not paying attention while driving towards the exit, isn't it?
No, I was paying attention.
Okay. So now the witness has said no, but if you see all the previous questions, he has said yes to all those questions. And necessarily the answer to the last question should have been yes, because he says that if he had sounded the horn, I would have paid attention. Then now I say that means you are not paying attention. So he says, no, I was paying attention, right? So if the court looks at this and says, of course, he was not paying attention. So that is a way in which you've cross-examined. So if I had asked him directly, Mr. Singh, were you paying attention while driving towards the exit? What would his answer have been? Of course, he would have said, yes, I was paying attention, right? So that is the way in which you ask a series of non-controversial factual questions and then ultimately build to the conclusion which you want from the case. Now we get to the next point of cross-examination of experts. So generally it is advised that you should avoid a lengthy cross-examination of experts because it gives them an opportunity to elaborate on their testimony. They may be able to explain something because they're experts, right? They know more about the subject than you do. So they may be able to explain something which otherwise they may not have explained. So you may not have understood something and you ask them that question and they're able to give a better explanation, and they actually strengthen the case of the party who has called them. Also, it is generally advisable to avoid cross-examining an expert on his own experience, because if you do not know what his experience is, please do not ask him 100 questions on whether he's experienced or not, because he may be very experienced and he may bring that out. He may not have brought that out in his affidavit of evidence, but through cross-examination, you may help him to bring that point out. So there is, in fact, a very good example of this, of how asking too many questions to an expert could be detrimental to the case of the cross-examiner. In this very good book called The Art of Cross-Examination by Francis Wellman. So this is a very, very nice example, and I'm going to really read out from this book to explain why it is advisable to avoid cross-examining an expert on his own experience. All right. So the example is this. An inexperienced young attorney was defending his client on a charge of murder. He was claiming that the death was a result of suicide and not homicide. So the charge against the cross-examining advocate's client was murder. The advocate was saying that he has not committed a murder. The death was a result of suicide. An elderly German physician had made the autopsy. So there was an autopsy of the body conducted by a German physician, and he had testified that after a very careful examination of the course of the bullet as it entered and passed through the body, he was satisfied that it could not possibly have been self-inflicted. So the doctor has given evidence that no, the person could not have died by suicide, he has died by murder. The witness offered diagrams illustrating his point, and if his opinion should be accepted by the jury, there could no longer be any question of suicide. So he has given very clear evidence, he has given diagrams, and he has showed how it could not be suicide. The young attorney started his cross-examination. The attorney on the other side started his cross-examination by addressing the witness in a rather flippant and disrespectful manner, which naturally irritated the witness, somewhat along these lines. So now I'm going to read out how the cross-examination goes, right? The attorney asks, Dr. XYZ, you seem very certain about your findings in this case. You do not give it as your opinion that the wound in this case could not have been self-inflicted, but you state it as a matter of fact. Swear to it as a matter of fact. Now I'd like to ask you, by any chance, is this the first autopsy you have ever made? I don't find your name anywhere in our local medical directory. Doctor says, sitting back in his seat and answering very quietly, holding up one of his hands and apparently counting his fingers. No, I can say that I have made a previous autopsy. Attorney, apparently encouraged by this answer, asks, well, could you honestly say that you have made 2 autopsies, not counting this one? Doctor, again hesitating and again counting his open fingers, apparently reminiscing, says, yes, I think I can truthfully say I have made 2 prior autopsies. Attorney is still more encouraged. So he says, well, can you go so far as to say that you have made 5 autopsies? Doctor, this time examining his outstretched hand very deliberately and apparently touching the tip of each finger as he counted up his cases before making a reply, and then looking up pleasantly at the attorney, says, yes, I think I can say that I have made as many as 5 autopsies. The attorney, who is now very happy, he's exultant and with a scornful smile walking towards the witness, says, well, sir, why beat about the bush? Let's put it this way. Can you say you have made 10,000 previous autopsies? The doctor says with a very broad, rather amused smile on his face, but still in a low tone, well, I think I can truthfully say I probably have. You see, I was coroner for 40 years in the city of Berlin before I came to this country. So what has the cross-examiner really managed to do here? The expert had not really set out his experience. He asked him so many questions that ultimately it was proved that the expert he was a coroner for 40 years, so he has an experience of 40 years. So what the cross-examiner has done is actually strengthened the case of the opposite party instead of his own case. So that is one reason why it is advisable to avoid, that is a very important reason why it is advisable to avoid cross-examining an expert on his own experience. And now finally we get to re-examination. So re-examination, as is set out in section 138 of the Evidence Act, must be confined to an explanation of the matters which are referred to in cross-examination. So it is not really open for you, for the party who has led evidence, to say anything and everything on re-examination. If there are certain points in cross-examination which you feel need to be explained, then those questions can be put in re-examination. Of course, section 138 also says that with the permission of the court, you can also introduce new evidence, new matters which were not referred to in your evidence in chief. But then in that case, the other side gets a chance to cross-examine because he never had an opportunity to cross-examine and thus no new points. Of course, with the new points will be put into evidence with the leave of the court. And again, examination in chief, re-examination are of the same nature. So no leading questions at all may be asked in examination in chief. They are disallowed in examination in chief and also in re-examination. They are disallowed. The answers must come from the witness. The evidence is of the witness. It is not of the lawyer. And therefore, the cross-examiner cannot ask leading questions. He must ask open questions. So questions which you do not ask in cross-examination must in fact be asked in examination in chief or in cross-examination or in re-examination. So I hope that we've been able to go through the basics of conducting a trial in civil matters, the basic and fundamental principles. So tomorrow, as I said at the beginning of the lecture, what I'm hoping to do is get all of you to participate, maybe interact a bit, and do three things. One, frame the issues in the case of Singh versus Bhatia, right? So I would really urge all of you to go through the facts in detail, because it is only then that we'll be able to conduct the session tomorrow. If you're not prepared, it's not going to help any of us. So therefore, I'd request you to please, if you haven't already gone through the Singh versus Bhatia case, please do go through it. And please come prepared tomorrow so that we can conduct the case. We'll first frame the issues. Then we have 4 witnesses. We'll determine what the aim of cross-examination of each of those witnesses is. And then finally, I'm going to call upon you, whoever is interested, of course, whoever volunteers, to ask a few questions in cross-examination to these witnesses. This is not really, to test anyone. This is not to make it uncomfortable for anyone. This is just so that all of us can learn, right? We learn if there are certain questions which we feel could have been asked in a better manner, maybe I could point that out, or maybe somebody else could point that out. It's open to everyone, right? So this is not a space where we are trying to judge anybody. We are just trying to learn. So I would really request all of you to prepare for the case and participate tomorrow as much as possible. Okay, so I think with that we come to the close of today's session. Thank you.